I'm Alex Berger with Berger Law in Marquette, Michigan. Today I'm going to be talking about guilty pleas and no contest pleas in Michigan courts. Most cases that are charged criminally end in a plea of some type, as opposed to going to trial or having the case dismissed. Basically, every criminal case starts off on the way to trial, and the parties negotiate, the prosecutor and the defense, and usually they reach some sort of a plea agreement. That's where the prosecution agrees to do certain things in exchange for the defendant pleading to the offense. One question that comes up for me pretty frequently is my clients asking if they can plead no contest to what they're charged with. And I'm going to explain today what the difference between no contest and a guilty plea is in Michigan courts. So a guilty plea is very straightforward. It's simply where you explain what you did, and the court hears that, and if they find that it meets the elements of the crime, they will convict you of that crime. It is just like if you were convicted at a jury trial, but you are the one who's incriminating yourself as the defendant. A no contest plea is slightly different. The result is the same. You are convicted. But instead of the defendant saying what they did wrong, someone else explains what the facts would show if they went to trial. So the result is that the defendant doesn't have to admit to doing anything, but they're still convicted of the crime. So functionally, conviction in either no contest or guilty plea. The big difference is what the defendant has to do in order to get there. No contest pleas require that the prosecutor and the court agree to do it, and it has to be legally proper. Michigan is unique in how they treat no contest pleas. No contest pleas are also called nolo contendere cases. That's Latin for the same thing, which means that you're not admitting guilt, but you're still convicted. So in Michigan, there was a Michigan Supreme Court case from 1975 called In Re Guilty Plea Cases, and it kind of set forth the parameters of what are okay pleas. And it talked a lot about when you can and can't do a no contest plea. That case sets out some of the situations you can do a no contest plea. The most common one that we see is civil liability, meaning if you admit to doing something that could be used against you in a civil suit to try to have you owe money to somebody. So if there's any sort of civil liability, or if it might interfere with a custody case, or there's any regulatory issues like you might lose your nurse's license, that is a reason to plead no contest if the conduct might implicate those things. And then you can just have someone else say what happened and move on. Another situation that's frequent, not as common, but intoxication or other loss of memory. So if you were too impaired to remember what happened, you of course can't admit to doing it, so they can do the same thing. It could be a no contest plea situation. The in re guilty plea cases kind of also sets up a few other ones which are less frequently used. If the facts of the case are too grotesque or too disturbing for the person to want to relive, they can do a no contest under Michigan law. And the other one that doesn't ever come up is if the person committed so many crimes that they can't differentiate between the different crimes that they committed to make the guilty plea. That list is not exhaustive, but it is mostly the parameters, the ones we see in Michigan. So you need to have one of the criteria that fit a valid no contest plea under Michigan law. The prosecution, the judge, and the defendant have to all consent to a no contest. And then also the plea agreement has to contemplate a no contest. Sometimes prosecutors require a guilty plea in order to get a plea agreement. So one interesting thing about Michigan is in 1970, there was a United States Supreme Court case called North Carolina versus Alfred. And out of that case comes what we call an Alford plea, which is a type of no contest plea. An Alfred plea allows someone to plead guilty for the reason that they want to take advantage of the plea offer. So you could be in a situation where you are innocent. You can't admit to doing anything wrong, but the risks of being convicted at trial are so high and the plea offer is so good that you are willing to admit, you're willing to take responsibility, you're willing to be convicted but you don't have a good reason to do that other than that you want to take advantage of the plea offer. That's called an Alford plea. And they're actually allowed in all states except for Indiana, Michigan, and New Jersey. They are also allowed in all federal courts. So Michigan stands alone with New Jersey and Indiana as jurisdictions that do not allow these Alford pleas. So we are stuck with the list that I said earlier, the most common one being civil liability, second most common one being intoxication, lack of memory. So a lot of people want to plead no contest simply because they aren't sure what happened, they're not willing to fully take responsibility, they're not willing to actually admit it, but they do want to take advantage of the plea agreement. So a lot of times we can fit those situations into one of the allowed types of no contest pleas in Michigan. There's one other workaround under Michigan law. There is a court rule which says that if you can plead guilty to the charged offense, they will enter a conviction for basically any other lesser or related offenses. So one situation that I have with this pretty frequently is, let's say someone was impaired by a drug, marijuana or cocaine or something like that, and they didn't consume any alcohol, but they want to enter into a plea agreement where they are convicted of operating a motor vehicle under the intoxication of alcohol as opposed to drugs, because it has a lesser driver's license consequence. So that person could admit that they drove under the influence of controlled substances, but then the court, under the court rule, can enter a conviction for a different charge, operating under the influence of alcohol. I know that's a little bit technical, but just the point there is that if you can admit guilt to the charged offense, then a lot of times you can get a better conviction that you couldn't admit guilt to. So to summarize, most cases enter into pleas as opposed to going to trial or being dismissed. Most pleas are done under an agreement, and most are guilty pleas, but there are quite a few no contest pleas. No contest pleas have to be agreed to by the prosecutor and the judge, and they have to fit under one of the Michigan allowed criteria for a no contest plea, the most common being civil liability issues or memory issues. I hope this was helpful, and if you have any questions, please put them in the comments.